It's a 10 It's a 10 series webinar where you can access business skills, range of business skills. All of these webinars are recorded, so you can go onto the YouTube channel. You can access the past webinars. The link is on the screen over there. You can also go via the QR code. You can go onto there and you can access the lineup. You can access the bios of the speakers. You can access the company websites. You can also access the archives with those recordings on there as well. This evening, we're going to be discussing an interesting topic. Every business is made up of human resources, and medical practices are by no means less than that. And the Alex Davies is an attorney at law, a respected attorney in labor law, and she's going to take us through the nuances of recruiting, hiring, dismissing, that whole process, and dealing with objections to any point in that process, and keeping yourselves out of the CCMA and worse yet, the labor court. Alex Davies is one of the partners at Pretorius Davies Incorporated, and she's going to take us through the presentation tonight on exactly that process. Alex, over to you.
Thanks, Ryan. And thanks to our sponsors, and most of all, thanks to all of the people attending the seminar this evening. I hope that I have some information for you that you will find useful and will help you with your daily jobs. Okay, so as Ryan's indicated, I'm going to be talking about basically from hiring to firing in a medical practice. But what I'm going to say to you today is applicable to business in general. Obviously, from a medical perspective, you have additional ethical rules and compliance aspects, which are even more onerous than a general business would be. Just in terms of my presentation, there is a section at the end for questions. I would love some questions from the audience. So if there are any questions, please feel free to pop it in the chat and we'll deal with that at the end. All right. So in terms of the process, we've got the recruitment process. Obviously, staff really are the lifeblood of a business. There's no two ways about that. That's something that every business must keep in mind, because at the end of the day, without your staff providing a good representation for the business, your doctors or the doctor involved, the business owner potentially, may be the best business owner and maybe the best doctor. But if your staff let you down, that's going to be the end of your business. And at the end of the day, one must make sure that you have the right staff. So we all know that finding the right staff or finding staff in general takes a long time. It is easy to just appoint someone and hope that they do the job. But if they're not the right staff member, then one way or another, directly or indirectly, there's going to be a problem that's going to come of it. One must not only take into consideration the time that it takes to get the right staff, it's also the cost involved. And that's, as I said, direct or indirect costs. So it might be direct costs of recruitment, for instance, but there's also significant indirect costs in terms of an employer's time spent recruiting someone and settling them in and getting things going. There's at the end, sorry, employers that are doctors have a high income opportunity, but ultimately you are generally selling your time. So the more patients that you can see, the more you can get in as an income. So the more time that you have that you spend dealing with HR issues or recruitment issues or performance issues, or any other sorts of issues, compliance, legal, accounting, those issues are taking away from your billable hours, your billable time that you can use to generate an income. And ultimately, you only have so many billable hours and billable time where you can see patients to generate the income. So, yes, you might not be paying directly to appoint the person or appoint staff, but there's an opportunity cost that is lost when you have to spend your time dealing with other aspects instead of generating money through your professional business. The other aspect that's also problematic is staff turnover is very disruptive to a business. So let me give you an example. On an annual basis, we have to do our audited financials and financial audits for the Legal Practice Council as an attorney. And the auditors that we used to have, and I highlight the word used to, we would deal with them on a yearly basis. So it's not a regular basis, but it's a yearly basis. And every single time I dealt with someone on our audits, there was a different person. There was a new person in the role. So every single year, I had to deal with getting someone else up to speed with how a legal business works, how our systems work, and all of that. And that staff turnover was very noticeable to me. And as a client, it was very frustrating. Needless to say, they were our auditors. They are no longer, as a direct result of the staff that they had. Not because of the quality of the senior managers involved or the owners of the business, but because of the lower end staff. And unfortunately, the impact of the lower end staff, one way or another, and it could be just more junior people, it could be admin staff, has an impact on the managers and the owners of the business. So it's really important for a business and continuity of the business to get the right staff and to keep them as long as possible in order to avoid staff turnover. That also gives a business much more stability because, as you would imagine, especially in a professional practice, such as the ones that you would have as doctors, there are a lot of technicalities and it is a specialized industry. So every time you get someone new, there is a big learning curve that needs to be implemented. So it's really important to get the right staff to be the face of your business right from the start. And rather put in a lot of extra effort right in the beginning to get the right people than sitting in a situation where you have problems and you need to deal with them and then replace them. Okay. So then if we start looking at the question of the right staff, this is quite a difficult aspect. And if you start considering it, who is the right staff? What is the right role? All of these things are aspects that you must consider as a doctor and potentially a business owner to decide what you want out of a staff member. And it's important to do this assessment well in advance of the recruitment, because then you know exactly what your needs are, what the person that you are intending to recruit will need to do, and you will be able to put together a job profile for this person. It's very important that you have these aspects outlined because simply appointing someone to do the job does not mean, without full details of the job and a job profile, you don't need to break it down into terms of specifics on a job description. You don't need to go that far, but you do need to go into the details of what the job would entail. Because, for instance, if you're just appointing someone to be in reception and answer calls, etc., and put consultations into a diary, that's one set of skills. However, if you are hoping to appoint someone to do the reception and then assist with the accounting side of it, that is a completely different skill set in the sense that a lot of the queries on the accounts would have your ICD-10 codes, would have to go through to medical aids, and the individual would have to understand and have a certain level of computer literacy to work with the systems with the medical aids, as well as understand the accounts and the finances. So if you're looking at that, you understand then that the person that you are looking to appoint will not simply be a receptionist, because you'll need added skill sets. And it's important that you advertise for that or you recruit with that in mind. It's also important because then you have a better idea of what your budget will be on salaries. So let's talk about the recruitment process. In terms of recruiting, we all understand that it is a frustrating and a time-consuming process. And generally, there are many, many, many applicants looking for a job that aren't necessarily suitable for a role. So you need to decide what you are looking for and what the best platforms are to try and find the right people. Practically, because of the frustration of the process and the length and the opportunity cost being that your hourly rates are so valuable, and your ability to see patients is actually your income generating platform, it often does make sense to use recruitment agencies. And there's nothing wrong with that, nothing whatsoever. However, please do your homework, no matter whether you are using a recruitment agency or whether you are going to do the recruitment yourself. And let me give you an example here. I'm sitting with a matter that a client used a recruitment agency for. And if I look at it, it took me about 10 minutes looking at the CV that was presented through the recruitment agency and a quick check on social media and LinkedIn for the same individual to see that 1 and 2 did not add up. They were not the same and there were discrepancies. So on the one side, the person was advertising essentially that she was almost a fully qualified accountant. On the other side, it showed that she was still studying. We received documents from the recruiter that said she was a member of a certain professional body. And when I had a look into this professional body, the professional body no longer existed in that form. They changed their names a number of years ago, also before the time she was recruited. So my client was simply provided with this individual, and they took what they were provided with at face value. They were also told that this individual would finish her studies during the year that she was appointed. And when I had a look at her academic record, it was quite clear that she was still doing a mixture of first and second year subjects, meaning it was absolutely impossible for her to finish her degree in the year that she was appointed. So those are small things, and that was very easy for me to determine. But those, and by all means, I'm not a recruitment specialist, I'm an attorney. I didn't do any of the checks that the recruitment agency would have, indicated that they had done. I didn't do any of those things, but in about the space of about 10 minutes, I realized something was not right here, and this woman was not actually qualified for what she was doing. The problem was my client had already had her in employ for a significant period of time, and now the problem only comes out when there's CCMA disputes. So please do your due diligence here. You don't have to necessarily go into detail and, but you need to verify things. You need to check references. You need to check that people actually have the degrees that they say to you that they have. Remember, in this day and age, it is very easy to get a degree forged. It is very easy to get an academic record forged. So if you do need a professional employee with some sort of formal qualifications, whether it be another doctor, whether it be your accountants, please make sure that the degrees are legitimate. This is a process that is quite easy to outsource, the same as your SAPS criminal clearances. That's not a problem to get. It is quite easy, quite painless. You just need the right person to do it, but please do those checks. The other thing that's very important, especially for a doctor who would be predominantly more in the environment where children would be involved, is to check the criminal registries in terms of crimes against children and to see whether anyone has been listed on that, because you don't want someone appointed in your practice that can be a risk and has a known risk attached to them. Rather have people that you are going to appoint rather hear the dirt, because at the end of the day, most people have some sort of history. Rather hear it up front and get it out there, because then you know what you're dealing with. If the person has a medical condition, you can accommodate them, but rather know that up front so that you know what you're dealing with. Okay, so then in terms of the appointment process, you need to decide what you need. Are you a small practice that's starting out and you maybe need someone half day? Or do you need someone full day? If you appoint someone on a half day basis, what is the chance that you're going to need someone within the next few months that is going to require a full day process? Do you engage with the person up front and say to them, at this stage, I'm looking at half day, but in 6 months' time, maybe we'll grow to full day. Can you accommodate that or not, potentially? Because you might end up with a situation where if you haven't considered all of these factors, suddenly you have to start appointing a second person, because the person who you have appointed, now that you can't just to get rid of, is not available, is not flexible after hours, etc., etc. So then we must also look at fixed term and permanent contracts. When would one go fixed term and when would one go permanent? And in terms of the different job roles, what would the purpose be of a fixed term contract? So if one looks at a fixed term contract, that really is supposed to be, especially if you're looking at the lower end employees that are earning under the BCA threshold, and I mean no disrespect in terms of the lower end, but it's in terms of the income threshold. That's what I'm referring to. So if you're earning under the BCA threshold, then fixed terms become more complicated. So when you put someone into a fixed term contract, you need to have a justifiable basis to do that. One must look at the justifiable basis for that. It's, for instance, if there is a fixed nature in the work, if it's a project based. So, for instance, a new clinic is opening, and for the first 3 months, there needs to be additional staff to help get things set up. But after that, it's not going to be required. Those sorts of things that are genuinely fixed term in nature can get fixed term contracts. However, if you've got someone earning under the BCA threshold, which is about 21,000 ballpark at the moment, but it is set to be reviewed in March this year. If you're looking at that amount and the role is actually a permanent role, then you don't have a justifiable basis to put them on a fixed term contract, and then you end up in the situation where they're deemed permanent employees. So if you have a receptionist, for instance, putting someone on a fixed term contract, and if she's earning under the BCA threshold, that person is not going to have a fixed employment by nature. A fixed term contract, it's not going to be a limited duration. it's going to be a fixed role within the business, unless obviously the business changes and you no longer need a receptionist. But one needs to look at whether there are justifiable reasons or not. Then if we look at permanent, most employees would be permanent unless there is a justifiable basis, obviously for fixed term. One must also consider in terms of fixed term, if someone does not include a clause in that contract saying that as a result of operational requirements, the contract can be terminated before the finalization of that fixed term, you will end up, as the employer, having to pay the staff member out for that complete fixed term, whether they work it or not. And that's a big risk. So then if we look at probation, probation's a bit of a strange one. And there's sort of two views on this, and I'll give you my stance on it. In terms of probation, basically the idea is to test out whether an employee is a good fit or not, and then only confirm them as permanent employees after their probation has successfully been finalized. The problem with that, and that's why I don't generally advocate for a probationary period, is because during the probation period, a employer has additional obligations to train and assist an employee and go through additional processes to upskill them to make sure that they can do the job and give them additional opportunities to prove that they can actually do the job. So there's additional process and additional onus on the employer during this period in the event that the employer wants to terminate. Whereas if the employer wants to go through a poor performance process, that can be done on any permanent employee after the probation is done, or if they are appointed without probation. So one must consider whether it's worth your while appointing on probation or not. Then something that is really important, when you've got the right candidate, you've gone through the recruitment process, you've decided it is the right person, please, please, please make sure that you've got a very clear offer to the person, very clear contracts of employment on what is expected, and both of those must be in writing. There isn't a legal obligation for a contract to be in writing. The obligation is for certain portions of what would normally be a contract to be in writing, for instance, the pay, etc., etc. But to protect yourself, please put both of those in writing and make sure that they are clear and complete. Then in terms of policies and rules, it's very important to have policies in place. Obviously, if one is looking at a business that is a multinational type business or multi-provincial, multi-jurisdictional, those are going to be very big businesses. And those types of businesses should definitely, without a doubt, have clear, detailed policies and rules that are in writing and are given to employees on appointment. But not every business is the size or has the support, the human resources to justify that. And what we do sometimes find is that in an attempt to comply with putting things in writing, people turn to things like Google to find policies, ChatGPT to draft them policies, and often those policies they seem good on paper, but when you actually look at what if you compare the policies or the rules, etc., to what actually happens in the real world in that workplace, they don't talk to each other. And that disconnect is massively problematic. So you need to decide for your organization what needs to be in writing and what doesn't. From my perspective, if you can put a number of policies in place that are clear, you don't have to write a 600-page document. But if you can put the basics in writing, that is always really good. Um, if you have a bigger operation, which may have, you know, 20, 30 employees, then by all means, things should be in writing because then you start getting into the numbers where it doesn't justify the risk that you don't have it. So please make sure when you've got a document, you go through it as the doctor, um, as the owner of the business, and make sure that it's actually applicable to your business. Because you do not want the difficulties and the comebacks that misfitting documents have. And just to give you an example on this, I'm involved with a matter at the moment where a company decided to outsource certain services to a service provider. So they outsourced a complete function of their role or of their business, essentially. The company has a service level agreement with the service provider, which requires the service provider to render complete services there in that division and to take full liability, full management, and full control of that aspect. The company then went ahead and appointed an employee in a general management position. And in her job description, the company included aspects such as she must manage the service provider. She must be involved with the management of the operations that fall under the service level agreement. So, what the company has in effect done in this situation is they've created a independent operation through the service level agreement, and now they've appointed an employee with impossible job description requirements that she must now be involved in the management of something that she cannot do because that has been completely outsourced. And that is simply an example of where two documents in a fairly small organization don't speak the same language. They don't work in parallel. They actually contradict each other. And that has caused the organization immeasurable damage in terms of the relationships between the parties and incredibly frustrating for all involved. But that's something that could have easily been avoided if the documents were actually checked up front. So just a small example on that. The other aspect is in terms of rules, the rules must be clear to employees. When one looks at drafting, you will sometimes find, and I'm sure that you get it quite often as doctors, well, anybody would, you get a lot of contracts, especially commercial contracts, where it is so unclear what is actually being said that to read between the lines and figure out what the detail is between all the T's and C's is quite difficult. And when you are appointing someone, you need to keep in mind who you are appointing. So are you appointing a service provider that is going to be rendering extremely technical services to you? Then by all means, you can have some technical aspects in there. But if you are employing a normal employee in the admin side of your business or a fellow doctor, but someone more junior, please make sure your contracts, your documents, they are all in plain English, so that there's no issues about, well, I didn't understand that, and that's not what that says. Because at the end of the day, if you need someone to interpret what is in your documents, then they're not serving the purpose that they are meant to be serving. Because ultimately, it should be so clear that an employee knows exactly where they stand right from the start. And there can be no doubt about that. Okay. All right. Then we're looking at the appointment process. I was involved in a matter a while ago where I nearly had heart failure. We're sitting at the CCMA, and my client is in the financial industry, And I look at the employee's bundle of documents, which includes extensive WhatsApps. And I go through this. My client hasn't disclosed this to me, that they communicate extensively with employees over WhatsApp. And I nearly have heart failure when I start seeing what's in these WhatsApps. And what I discover is that in this company, where there's obviously very sensitive financial information from the company's SaaS passwords, their usernames, their financial reports, you know, all of those sorts of details. This has been freely shared with staff on their private WhatsApps. This now, in the event of a dispute with the employer, this now forms part of a CCMA bundle. And obviously, there is a major risk because now an ex-employee still has access to their clients' passwords, to their SaaS profiles, their usernames, etc., etc. And not only do they still have access, that information has now been shared in the forum of the CCMA. It is now shared with me as the representative of the employer. It is shared with the commissioner. The bundles at the CCMA don't necessarily stay in the commissioner's personal hands. They would often go into the admin staff's hands as well, and they would then remain in the CCMA's possession if the matter continues, and ultimately, if the matter goes to the Labour Court on review, those very same bundles with all of this information in it, all of the client's personal private information, then goes on to the Labour Court, and at that stage, it becomes a public document, which becomes publicly accessible. Anyone can go and pull the file. So what has happened is this client, by allowing employees and actually engaging with employees over a WhatsApp forum with this type of information, actually exposed their clients to the risk of their information becoming part of the public domain. Let's forget all of the other risks in terms of POPI and all of those risks. And when I spoke to my client about this, being there in the financial industry, I would have assumed that they would have been quite sensitive to this, similar to the doctors who would have a very keen sense of privacy for patients, confidentiality, etc., with the ethics that apply to you. And my client, which was not a small business, didn't seem to find it strange. And what later came out is that this very same client was allowing staff to be appointed and using their own laptops. So not only did the problem happen in terms of WhatsApp and information being shared privately there, it also happened in that the client was allowing these employees to bring in their own resources to do their jobs. And that is inherently problematic, as the client found out, because when the employee decided to just up and leave, you have no control over that device. You have no legal basis to say that device must be returned and scrubbed by you as the employer. So you actually have no control over the information on that device. And being a doctor, being in the profession that you are, the information that you handle is extremely sensitive, probably much more so than the financial industry would be. So why I'm raising this with you is because there's often a lot of unintended consequences of something that may seem very, very innocuous. So in terms of that, it is really important to consider what happens in terms of how an employee uses hardware user systems in place, and what control you as the employer would have over that information and over the systems. It is critical that you as the employer have control over what happens to the information for your clients and your patients. It is critical that you have backups in place, because if you don't have that, you may very well find that if an employee is unhappy with you, then they just decide to leave and and destroy all the information, and then you're stuck. So it's really important that you are in control of things. It's also very important to have clear expectations, rules, and procedures. So in this, whether it's in the form of an email, whether it's in the form of regular updates to staff, whether it's in the form of simply a poster that's put on the wall, or at reception, etc., just have some guidelines on this and have proof of it. Okay. Right. Okay. In terms of keeping staff happy and keeping them for as long as possible, it's important to look at where staff can have further training, for instance, further performance management, and that's in a positive and a negative way. If someone is not performing properly, then an employer has to step in and say to them, these are the aspects that you're not performing on. If an employee is, however, shooting the lights out, then that employee should be rewarded for that. And obviously, in a very small environment, one is not necessarily going to have very detailed performance agreements, etc. But in a larger environment, 10, 20 people plus, it does help to have those in writing. And unfortunately, then we end up with disciplinary management. Again, it's very important to have clear understanding of what is expected of an employee, and also clear indications of the consequences. So, although it's nice to have a pack of rules and a document that says this is your disciplinary process, it's also important for engagement and a free flow of information between management and employees. Because ultimately, if someone is doing something wrong, normally, well, if it's something small, it can easily be addressed by simply pointing it out to them, rather than necessarily having the approach of, here's your warning, you've done something wrong. At the end of the day, you want the person to correct their behavior, but the relationship needs to remain as good as possible. Because as soon as one starts losing that relationship, then you lose the loyalty and the respect of the employee, and will probably lose the employee at some stage, or will potentially have to fire the employee. And that's obviously not ideal for any business. So it's really important to have an open communication with employees. Okay. Then we go on to the dreaded termination process. Okay, so we've got a couple of options here. And obviously, I'm not talking about the option of termination by death of either party. That's self-explanatory. But when we look at different options of termination, one must consider the risks for an employer and the different processes. So if we look at the option of the first one on the screen, that is the option of a resignation. So that's when an employee voluntarily terminates their employment, and that's essentially the best case scenario for an employer, unless the termination is a constructive dismissal. So the employee is forced into resigning because of intolerable circumstances. But if someone resigns, there's essentially no real risk for the employer relating to the termination, and that's your safest option. Then in terms of disputes or potential disputes, you have the option of agreeing to a termination, and that's normally a separation agreement or a mutual separation agreement, but ultimately it's a termination by agreement. So that's also not a dismissal. And the importance of that is because the term dismissal is what falls under the Labour Relations Act, and that's where you get your comebacks. Okay, so in terms of an agreement on termination, it's really important that this must be in writing. So often parties will decide, look, the relationship's just, it's not working anymore. For one reason or another, either the parties don't like each other anymore or something has gone wrong, and the employment relationship just cannot continue. So what a lot of people do then is they will enter into an agreement to terminate the relationship. And the reason for this is essentially a question of liability. So in the agreement, one would determine what your agreement is regarding liability going forward. And that goes both ways. So for an employee wouldn't want a dismissal on their record, and wouldn't want negative reference or the risk of a negative reference for job prospects going forward. And on the other hand, an employer wouldn't want the risk of litigation, generally the CCMA or a labour court dispute, after termination. So often there's a bit of a quid pro quo that happens, and the parties decide, okay, the employee will leave. Generally, the employee will be paid X amount of money, and the parties both waive their rights against the other party. Again, here, please get professional advice. As with the contracts, make sure it's all in order and make sure that there is a clause which says that there is a full and final settlement. Otherwise, your agreement is essentially worthless. Then if we look at dismissal, this is when an employer initiates the termination of employment. And this would include the aspect of constructive dismissal, which I referred to earlier. So with all of the aspects that fall under the category of dismissal, an employer is at risk. And this is really where the risk comes in with terminations. And this is why it's so important to appoint the right staff so that you minimize your risks on termination. So in terms of dismissal, the risk is that if the matter goes to the CCMA, and I refer to the CCMA because specific disputes go to the Labour Court, and there's a higher risk there, but at this stage, I'm referring to the CCMA. So in terms of that, an employer has the onus of proving that the dismissal is fair. So there's an obligation if you fire someone and you then end up at the CCMA that you as the employer have to justify your dismissal of this employee and your action on both a procedural and a substantive basis. And what that means is the reason for dismissing the person being the substance, and also that you followed a fair procedure. Okay. So then we have the nice new guideline of the new Code of Good Practice on Dismissal, which came into effect last year. There was previously one, which was Schedule 8 to the Labour Relations Act, and you will still see that commonly referenced, but we do have a new one that is in effect. And this talks to the different categories of dismissal. It does provide assistance to employers, so it's really important if you are looking at dismissing someone that you have a look through this document. It is freely available on the website, on the internet, and you're more than welcome to pop me an email or get in contact with me if you want a copy and you're struggling to find it. But in terms of this document, it provides different types of processes for probation. Then obviously, we've got the constructive dismissal, which doesn't obviously have a process. We've got misconduct processes, incapacity, poor performance, and operational requirements. And operational requirements are your retrenchments. The process for operational requirements is also set out in the Labour Relations Act in terms of Section 189 and 189A. That is a specifically very detailed process. So if you are ever looking at retrenching someone, there are very, very clear rules on that. And in terms of the Basic Conditions of Employment Act, there are also very clear benefits that accrue to an employee who's being retrenched. There are also tax benefits and tax breaks for employees who are retrenched. So it's really important that you get the processes right. And thankfully, this Code of Good Practice does provide assistance with that. Okay. It's really important that you get the processes right. I cannot emphasize that enough. Okay, then if we look at the Code of Good Practice for dismissal, this is last year's one. And I've highlighted an extract from the code, which I've included in the slide. And essentially, I just want to read it for everybody. The key principle in this code is that employers and employees should treat each other with mutual respect. This code places a premium on employment justice, the efficient operation of an employer's business, and the expeditious resolution of disputes. While employees should be protected from unfair action, employers are entitled to satisfactory conduct and work performance from their employees. So in terms of that code, you can see that there's a balancing act that is in place here. And what I've put on the screen now is a judgment from the Labour Court, and it's referred to as one of the locus classicus, or the leading cases on disciplinary hearings. This is the Avril Elizabeth Home for the Mentally Handicapped versus the CCMA and others. And you will find the judgment online, but again, I'm more than willing to supply it to you. But for your purposes, the extracts that I've put on the screen should be sufficient. And what it basically deals with is an assessment of the requirements in terms of the Labour Relations Act versus the very strict criminal justice process, and evaluating whether disciplinaries need to be very formal in terms of similar to the criminal justice process, or whether less is required. And essentially what the judgment said is that you do not need to follow a very formal process. One needs to give an employee an opportunity to understand what the complaint is against them, an opportunity to respond to the complaint, and for there to be genuine engagement on the issue, as well as the employer considering the representations made by the employee before a finding is made. Practically, however, it's quite rare that someone sits around the table with their employee and then has a disciplinary in that way. I accept that from a legal perspective, there aren't set requirements for a disciplinary. But practically, if an employer has to prove that there was a fair disciplinary process and that the employee is indeed guilty and was proven guilty at a disciplinary process, it is going to be very difficult to do this unless there are some procedures in place. So it's very important to put together a charge sheet, for instance, because that sets in black and white what the issues are. Then an employee has an opportunity to prepare on that. One should look at a minimum of 48 hours preparation time for a hearing for an employee. Then one must consider whatever the employee has to say in their defense. That's very important because it goes back to what the Code of Good Practice and in the previous screen that I showed you talks about, where there must be engagement between the parties. So with that, Although an employer can personally chair a disciplinary hearing, one does run the risk that the employer is seen to be biased because it is their own dispute and their own complaint, essentially, that is going to be considered. So one sits in the position where it is often a good idea, especially for a more senior employee or a more high risk employee in terms of salaries, um, or litigious type employees, that it is much better to have an external independent person come in and chair your hearing, because then at least you have a bit more protection to say the process um, was fair and was correctly handled. So the legal requirements are fairly low, but practically, I would suggest having some formalities in place. Okay. Then if we look at disputes after termination of employment, and this is where things get a bit difficult and high risk for employers, so it's important to know. I've included the sections of the Labour Relations Act, which is applicable in the event of dismissals or unfair labour practices. Now, I haven't included unfair labour practices in the scope of this presentation, but they do apply as well. So just in brief, if an employee is found to be unfairly dismissed, procedurally and substantively, or procedurally or substantively, they can get up to 12 months compensation. And that's essentially the earnings that they had at the time of their dismissal. If the employee is found to be dismissed on a automatically unfair basis, and that relates to employees terminated for a discriminatory basis. For instance, age, gender, sex, race, sexual orientation, medical, HIV status, etc., etc. If there's any type of dismissal on that basis, you're looking at a maximum of 24 months compensation. Realistically, 12 months doesn't necessarily happen in the CCMA, but the risk is there that it could happen. So if you're looking at an employee who earns 100,000 Rand a month and they're found to be unfairly dismissed, you're looking at a 1.2 million Rand claim. Obviously, if you have a person earning 10,000 Rand a month, then significantly lower, but there is still a big risk. The very problematic aspect is not only the finances, because often an employer is going to be a lot more willing to simply pay the problem to go away, even if they lose a CCMA case. The problem is if this employee now has to come back. So in terms of Section 193 of the Labour Relations Act, the primary remedy in the event of a CCMA commissioner finding that an employee is unfairly dismissed, is actually to reinstate that employee or re-employ them. And one can imagine that this is extremely difficult for employers to deal with. And this will also result in a lot of review applications simply because the employer does not want the employee back. So in terms of this, if it's only a procedural unfairness, then one does not run the risk of a reinstatement. But if it's a substantive based unfairness, then the automatic and the primary remedy is supposed to be retrospective reinstatement, unless the employee doesn't want reinstatement, and it's not reasonably practicable to take the employee back, or that it's simply the relationship has been destroyed, essentially. So if you think about it as an employer, you run the risk of someone coming back, being retrospectively reinstated for the whole time that they didn't work. And unfortunately, although the CCMA generally is quite efficient, not all of the disputes are handled very quickly. So, for instance, just as an example, I'm handling a matter that is a part-heard CCMA matter um, in my local CCMA division. And this matter, the employee was dismissed in March last year. So we're essentially looking at a year's worth of salary for a reinstatement. Um, there are disputes that continue for significantly longer than a year. And as a result of that, there is a very big risk to an employer if retrospective reinstatement is granted. So if you are ever in a CCMA dispute, it is really critical that you deal with the aspects that are on the screen at the moment to justify that an employee should not be retrospectively reinstated. Okay, then I'm essentially almost at the end of my presentation. Then I just want to touch on restraints of trade because this is something that is quite important in the medical industry. A number of years ago, there was a big exodus from a large biomedical industry company, and essentially all of the staff were moving to a competitor. And there was urgent application after urgent application after urgent application in the Labour Court because the impact of these staff leaving, and they essentially had the connections with the doctors, was massively detrimental to the organization itself, the business itself. So there's obviously a lot of value in the businesses that run, and each of you would have your own different industries that you'd be in, own specialities, own types of or sizes in terms of your operations. So in terms of this, it's just important to understand that a restraint of trade is applicable to protect your business interests. It is not applicable or appropriate to have a restraint of trade, for instance, on a receptionist, because that receptionist cannot take away your business and take it to a competitor. However, if you, for instance, have a specialist department that you put together, and each of the doctors within that department or salespeople, if they are not necessarily medical, if they are within that and they hold customer connections or confidential information that isn't in the public domain, it may very well be worth you appointing them based on restraints of trade agreements. And that is purely to protect your business, not to prevent them from having gainful employment. So what you might find is that a restraint of trade must be drafted 100% correct for your company. Please do not go and get a Google example on that. It's not going to help you and it's not going to protect you. So just as an example with that, there was a matter a number of years ago in the Labour Court where a hairdresser was subject to a restraint of trade. And this hairdresser was essentially a normal hairdresser in the normal sense. And the court threw out the restraint of trade. The employer lost with costs because there wasn't a proper protectable interest on the business. However, there were other disputes which happened where there was a restraint of trade against hairdressing staff, but they weren't actually hairdressers in the normal sense of someone who would cut your hair and dye your hair, etc. It was employees who were involved in hair replacement processes and hair rejuvenation, etc., etc. Not medical doctors, but they had extensive training from their employer, which elevated them far above what would be considered a normal hairdresser. And what those employees had essentially done is they had a very close relationship with their staff, or with their clients. They had walked a long road because the processes were, months, maybe a couple of years long, where they would see the client on a monthly basis. They would check the hair on a monthly basis, put in new extensions, etc., all the technical aspects. So they had a very close connection with these clients. And as a result of that, when these staff members left and they started up their own shop a couple of kilometers away, all of the business's clients who were associated with these staff members then left as well and moved to them. And realistically, there's nothing you can do about those clients leaving. The only thing that you can do is try and protect your interests in advance by virtue of a restraint of trade. So if you do feel that you are in an industry where you may be at risk of your business being taken away by staff if they leave, then that is something that you must get professional advice on, and you must consider incorporating in their contracts of employment right up front when you appoint them, or by agreement at a later stage if they are willing to agree at a later stage. Okay, then we are on to the questions, and I've thankfully just finished in time.
Wonderful. Thank you, Alex. That was really informative. I see that we don't have any questions from the audience, and we are 3 minutes over. So I think that we're okay. I think that you've covered everything during the presentation. I think that if anyone does have any questions, they can address it via the consultations. On the screen at the moment, there is a QR code. If anyone would like to receive a 15-minute free consultation with Alex, and then address any questions, and perhaps recruit her for any of the services, you can scan that QR code on the screen right now and schedule a consultation with Alex or with any of the other presenters that we've got during the webinar series. Alex, thank you very much. I actually did have a couple of questions for you, but I don't want to keep anyone. I know everyone's looking to get back to their families and their dinner, and I know that you are too. Thank you very much. Thank you everyone for attending. This recording will be uploaded to the Docio YouTube channel. Have a good evening. Thank you. Bye bye.
Thank you. Bye.